If you think your son is there, you think your son is in danger, which it doesn't appear to be because you were intoxicated, you need to call the police.
Yes, ma'am.
So, do you have custody of your son now?
A mother shows up at someone's door at 5 in the morning looking for her son. But what she did next got her charged with a felony and landed her in front of Judge Boyd.
All right, court is calling 2025 CR 003550 State versus Leslie Martinez. Can I have parties announce?
Rick Minion for the state of Texas.
Jim Alters door for Leslie Martinez.
Are you Ms. Martinez?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor, I did.
Court will find that the state is in compliance with discovery. Ms. Martinez, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney?
Yes.
Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, we will be waiving paragraph A and proceed on paragraph B.
All right, any objection?
No objection.
Did you review the court's admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with burglary of a habitation? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes.
All right, off the record for a moment. Oh, they were saying it was a false alarm. We're back on the record.
My wife is outside. She just let me know.
Okay, all right, we're back on the record. Did you understand if you have a plea bargain agreement with the state, the court does not have to follow your plea? If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
All right, so you understand what your rights are.
Yes, ma'am.
You're giving up those rights by entering into this plea bargain agreement. Did you understand that?
Yes.
And are you intending to do that?
Yes.
All right, did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and the court could sentence you up to 20 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
Deputy Laura, can you have them move to the other end? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
She does, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes to both questions.
Ms. Martinez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
I did.
According to the plea, there's a $1,500 fine. State recommends deferred adjudication and there's to be no contact with the complainant. Did you understand that to be the plea?
Yes, ma'am.
Defense is at the plea?
Yes, Your Honor.
State is at the plea.
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, ma'am.
Outside the agreement, the state is recommending that your community supervision be for a term of 5 years. There'll be 100 hours of community service restitution, anger management, TAP evaluation, follow our recommendations, the MRT and parenting classes. But you understand those are recommendations from the state and the court does not have to follow those recommendations.
Yes.
Then to paragraph B in the indictment, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor. At this time, state offers into evidence, State's Exhibit 1 with all attachments.
No objection.
All right, and State, have you had a chance to speak with the complainant?
We have, Your Honor, the complainant would like to come in and give a victim impact statement. Unfortunately, she was unavailable to come in today. We are asking that sentencing be delayed until Thursday so she can come in and do so.
All right. Thank you.
Yes, Your Honor, thank you.
Did you review the waiver and stipulations with your attorney? Did you understand it?
Yes.
Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find that if there is sufficient evidence to find you guilty, the court will defer finding of guilt as you've applied for deferred adjudication. So, counsel, I can sentence her today and order her to be back here on court on Thursday, and they will give a victim impact.
That will be fine, Your Honor. May I ask that the court may consider for the fact that I'm court appointed with regard to the fine, maybe probating a portion of the fine.
Yes. All right, so why did you go over to this house?
So I was looking for my son. His dad had taken him, so I went to look for him at his aunt's house because I thought they were there.
So why do you need to look for him? Because he has your son.
Because it was we had a fight, so he didn't leave in good terms. So I was worried about my son.
All right, so this is what people need to understand, and I don't think people understand this. Even though you're a mother of the child, that's the father of the child. And when people have a child and the father takes the child, sometimes mothers feel as though, well, I'm 100% should have the child, and he should only have the child when I say so. Unless you have civil documents that say that, that's not the case. So you're entitled to have the child, he's entitled to have the child. Hopefully, people will be responsible adults and they won't be running around, causing problems or taking a child out of frustration or anger. You have to remember, the father of your child is the person that you chose. You thought this would be a great person to have a child with, and so that's the father of your child. Now, it says in here that she told you that her brother wasn't there and the child wasn't there. So why are you still trying to force your way into the apartment?
I was not trying to force myself into the apartment.
Well, that's why you're here. It says victim.
She claimed she was just looking for her child, but Judge Boyd pulled out the police report and started reading it out loud, word by word.
Victim stated to me that on July 17, 2024, around 050 hours, suspect made the location. And that's military time, so not a good hour to begin with. Victim stated that she was awoken by hard banging on her front door. Victim stated she opened the front door thinking it would be her mother. Victim stated when she opened the door, she noticed the suspect, that's you, who appeared to be intoxicated, who told victim she was looking for victim's brother and her child. Victim stated she advised suspect they were not at the location and for the suspect to leave. Victim stated she attempted to close the front door. Victim stated suspect began to force her way into the residence and made entry via her foot and hand. Victim stated suspect was approximately 2 steps in the apartment and any entry of any part of the body, be it a window or whatever, that's burglary of habitation. Victim stated there was a verbal altercation between the door while holding back suspect from making further entry. Victim stated suspect caused bodily injury when she elbowed victim and caused the door handle to hit victim in the left buttocks. Victim stated there was shoving and pushing with the door between the victim and suspect. While speaking to the victim, she was able to show me bruising on her left forearm and a photograph of the bruise on her left buttocks. Victim stated witness woke up and assisted victim closing the door. So maybe you don't remember, they say you were intoxicated. So here's the thing, when people don't want you at their home, regardless of what it is, you don't force yourself in. If you think your son is there, you think your son is in danger, which it doesn't appears to be because you were intoxicated, you need to call the police.
Yes, ma'am.
So, do you have custody of your son now?
Yes,
And the father of your son, does he see your son?
yes,
No problems? Now you're here with a felony hanging over your head.
yes, ma'am.
So is this the only child you have?
Yes,
Are you employed?
yes.
What do you do?
I work at a call center.
Doing what?
We ought to make appointments for hearing aids with Miracle Ear.
Okay. Any drug use?
No.
Any alcohol use?
No.
You're not allowed to drink any alcohol while you're on probation. Do you understand?
Yes, ma'am.
All right. There's a $1,500 fine that will be probated. There should be no contact with the complainant. Regular reporting by Zoom or in person. Regular random UAs. 5 years deferred adjudication. 100 hours of community service restitution. I'm going to order parenting classes. Once that's completed, the community service hours will be deemed satisfied. TAP evaluation out of custody, follow recommendations. And anger management classes. Probation is and field visits 1 time per month for 3 months. Probation, is there anything else? Sorry?
Employment.
Oh, thank you so much. Proof of employment within 30 days, no employment as a home health care provider or with minors. Is there anything else, probation?
Okay.
All right, anything else you need from the court?
No, ma'am.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes,
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
yes,
All right, we can go off the record. So State, here's the thing. I know the sister, I'm assuming she's the sister of her boyfriend.
Sister-in-law.
All right, so you may want to talk to her. I don't know if the brother wants her to do a victim impact statement with her, but if they are all trying to be a family, may not be the best. But if she does, this is going to come back. You're going to be back in court on Thursday to hear her victim impact. Do you understand?
yes, ma'am.
All right, Norma, if you'll give her a reset for Thursday, if there's anything else you need?
No, ma'am.
All right. On probation, to be successful in this court, communication is key. If there's an issue, let me know. If you feel that you've spoken with probation and probation is not addressing it, come back to court, okay?
Okay.
All right, good luck to you.
Thank you, ma'am.
Thank you.
You're welcome.
Judge Boyd's message was clear. The father has just as much right to that child as you do. Breaking into someone's home at 5 a.m. is never the answer. One more mistake, and she loses everything.